Welcome everyone to today's to the inaugural AICL-AIDC Junior Scholars Forum, organized in collaboration between the Center for Asian Legal Studies and the Center for Comparative Constitutional Studies at Melbourne Law School. My name is Jaclyn, and I'm the director of the Center for Asian Legal Studies, and I'm co-convening this event with Dr. Scott Stevenson at Melbourne Law School and Professor Adrienne Stone, who is a professor at Melbourne Law School, as well as the president of the IACL, the International Association for Constitutional Law. It is wonderful to have all of you join us today, and especially to all our amazing and esteemed keynote speakers. Now, this event has been a long time in the planning. Adrienne and I were just chatting about how we first started thinking about this event with Scott in 2017, late 2017. And we had hoped that we would be able to put this, to welcome our participants in 2020. But as we all know, these are extraordinary circumstances that we find ourselves in, and therefore, instead of having an in-person event, we are having an online event. But in some ways, it is a blessing in disguise, because this means that we could have many more of you join us for this particular keynote panel. Now, the Junior Scholars Forum, we will be featuring 26 scholars who were chosen for a very competitive pool of about 100 applicants. And we're grateful to all our 21 commentators and guest speakers who will be providing their insights and expert comments on these 26 papers that will be featured in the next few days. Now, we really thought of this Junior Scholars Forum as a way to diversify platforms for junior scholars of constitutional law to come together and to receive feedback on their work. And for this particular keynote, we wanted to share with you the insights that our keynote panelists will have on certain methodological approaches to comparative constitutional law. So without further ado, allow me to hand over this time to Professor Adrienne Stone, who is the president of the IACL, to say a few words of welcome. Adrienne.
Thank you, Jaclyn. Welcome, everybody. It is really a rare pleasure to welcome you to what is an inaugural event for the IACL, and which, as Jaclyn mentions, I've been looking forward to for such a long time. Indeed, the creation of a specialised forum for junior scholars was one of my principal priorities when I became the president in 2018, though, as Jaclyn mentions, I began discussing the idea with her and Scott Stevenson even earlier at the end of 2017. And it is so wonderful after all of that time to see it come to life as a collaboration between the Centre for Asian Legal Studies at the National University of Singapore, the Centre for Comparative Constitutional Studies at Melbourne Law School, and the International Association of Constitutional Law. Our idea was to provide scholars in the early part of their careers with opportunities for the intensive workshopping of works in progress, as well as mentoring from senior scholars, and for the discussion of other aspects of academic life, and for building networks with peers. These are all things that I found enormously productive in the early part of my career, and we do want the IACL to be a forum for creating exactly those kinds of conditions for successful academic life. The process of designing the workshops began in earnest in 2019 with a call for papers that met with a very large number of responses, and I congratulate the 26 participants who will have their work featured over the coming days. And of course, our original plan was to meet in Singapore in July 2020, and even a year later, the pandemic is still preventing us. Of course, the worst thing about the pandemic is the threat to everybody's health and welfare. And on behalf of the IACL, I send all participants and everyone here today best wishes for health and safety, and I hope speedy vaccination. I am so thankful to Jaclyn Nao and Scott Stevenson that they have ensured that we can continue our important work as constitutional scholars, and that the association can continue its role as a forum for global constitutionalists over the coming days. And I thank also the teams who have behind the scenes put in so much work to make this happen. So it's time now to begin our first keynote panel, and I will be delighted to introduce 4 exceptionally distinguished speakers whose presence greatly honours us today. We will hear, and then we will hear from them in the following order, and I'll introduce them briefly all at once before we start the panel. We will hear from Professor Raul Pangalangan, who is a judge of the International Criminal Court and a professor of law and a former law dean at the University of the Philippines. I'm delighted to say that he's also a former colleague on the executive committee of the International Association of Constitutional Law, where I was honoured and delighted to know him. We will then hear from Scheppele, who is the Lawrence S. Rockefeller Professor of Sociology and International Laws at International Affairs in Princeton, and a current member of the executive committee, amongst her many distinctions. Cheryl Saunders, my colleague at Melbourne Law School, where she is Laureate Professor Emeritus, will also join us on the panel. And of course, she is a former president of the International Association of Constitutional Law and truly a pillar of the global constitutional law community. And then lastly, we will hear from Professor Kevin Tan, who is Professor in Constitutional Administrative Law at the National University of Singapore, and an immensely productive and important scholar. So thank you, the 4 of you, for agreeing to share your great wisdom on the key methodological and substantive trends in comparative constitutional law. I look forward to your remarks, and I'll hand over, first of all, to Professor Pangalangan.
Thank you so much, Adrienne. I thank and congratulate Adrienne, Jaclyn, and Scott for this initiative. The young scholars are very lucky to have this forum. How I wished I had these when I was doing my own doctorate decades ago. So let me jump straight to my topic. I have just ended my work here at The Hague as a judge. And when I was elected 6 years ago, I thought that the hottest legal debate would be about the tension between international courts and national sovereignty, about the principle of complementarity, that the ICC is only a court of last resort, and the first resort being that of national courts. But I was wrong. The biggest debates in the court were actually in comparative law, and more specifically, the tug of war between what for me was the American constitutional guarantee of due process of law vis-a-vis the European continental notion of fair trial rights. I actually thought that these 2 big legal traditions, the Romano-Germanic tradition on one hand and the Anglo-American tradition on the other, simply used different terms for the same thing. But apparently the differences are much deeper. Apparently, in historical context, the view was that the precursor court, the Yugoslavia Tribunal, was so heavily influenced by the Anglo-American tradition that the ICC was seen as the chance for the continental guys to set things right. And in fact, in the early days, even the innocuous term filing of the indictment was seen as too Anglo-American. And the problem was, to begin a case, you need a document containing the charges. So what is it called today in the court? It is called the document containing the charges, the DCC, just to avoid what was a term associated with one tradition. I hasten to assure you that these debates had quieted down by the time I joined the court. And in fact, by 2016, when I headed a chamber on the head of a religious police who destroyed mosques and mausoleums, there was an issue, what apparently was just a procedural issue. He pleaded guilty to the crime. But a plea of guilt was never accepted until then by the court, because again, in the civil law tradition, apparently the plea was not enough. It was merely the subjective truth, and what they preferred was they called the objective truth established by independent evidence. Well, just to cut to the chase, the 3 judges, 1 Filipino, 1 German, and 1 Francophone judge from the Congo, agreed to abbreviated hearings. His cohort of the accused, who did not plead guilty, is actually on trial now for a trial that would actually last 2 to 3 years. This goes fundamentally into the nature of justice that we are giving to the accused. It goes back to the all-time classic, the civil law tradition, where John Merriman asks, who is the main protagonist in the civil law, in the common law? And I ask, who is the main protagonist in their courts? The comparative perspective will tell us the different roles expected of judges and of lawyers and of witnesses, and even the meaning of the presumption of innocence or of the prosecution's duty to prove guilt beyond reasonable doubt. But let me now proceed to what I consider the challenge. It is the overlap and convergence of disciplinal lines. These debates are open and widely recognized between the 2 traditions. And yet it struck me whenever I said that what we were debating was actually a comparative law issue, I usually got strange looks. But to the extent that the common law civil law divide occurs in the context of larger treaties, human rights law, international humanitarian law, it becomes simply about the differential interpretation of the language of treaties. Indeed, at some point, the debate is seen merely as an issue of different ways to interpret our own governing charter, the Rome Statute. But the divide between the 2 traditions actually dominates even the interpretation of that statutory language, such that even if either side aims at the same goal, basically to finagle the desired meaning out of written text, still the justificatory and intellectual techniques differ. The civil law relying on natural law thinking, the common law relying on some version of legal realism. Accordingly, I think it is important, especially for scholars, to affirm and recognize, to confront the comparative perspective that is being used in such a debate. Let me proceed to my second point, which I call the double burden of the Asian comparativist. The Asian comparative law scholar has the additional burden of not just looking at the same laws as they exist in different jurisdictions, but to look at the place of the law itself, the phenomenon of law vis-a-vis other forms of social organization. For instance, many post-colonial constitutions have adopted directive principles. But I will say it took the Indian Supreme Court to show the full power of otherwise merely hortatory directive principles. Otherwise, modern Asian constitutions merely borrow the language of liberal democracy to pursue illiberal goals. In other words, for the Asian comparativist, part of the analysis will have to include the anthropological or historical context of legal phenomena. Otherwise, we end up studying law as a phenomenon that possibly plays a different role in different jurisdictions. Finally, and by way of closing, I would look at ASEAN comparative law as a way of understanding ASEAN societies. We are a region that tends to, notoriously, to paper over genuine conflict, capable of ignoring the elephant in the room. And other fields of law, international human rights law, for instance, or international humanitarian law, can look at the same phenomenon, but in ways that can be divisive or inflammatory, or at the very least are explicitly political. I think I venture to say that comparative law will enable us to have scholarly reflection on these issues without becoming explicitly political. I would like to offer actually a study in which I participated in with Jaclyn, Jaclyn, if you recall our project on religious freedom in the ASEAN, of course, we could not have avoided the highly contested issues on a topic like religion and in an area like the ASEAN. But I think because of the comparative approach, we had to, and we were able to deal with these issues with the requisite scholarly distance and to be able to confront these issues and still avoid the otherwise inflammatory contexts that human rights or international humanitarian law would offer. Allow me to close on that point. Thank you.
Thank you so much. And now let me invite Professor Scheppele.
Thank you. And I'm going to share my screen with some slides, and I hope you can all see it. And I'm grateful for this transition, because I'm also going to make the same argument that diving straight into the political debates, which I do on occasion in places that I know, but isn't the stance of a scholar in a lot of these topics. And so what I want to talk to you about is a phenomenon that's happening in a lot of different parts of the world, where countries that we thought of as constitutional democracies are becoming not either constitutional or democracies. And so what I want to say is that I think one of the important topics of our moment is how to study what I'm calling a counter-constitution. And that requires actually thinking about constitutions sort of differently than the way we've typically thought of them. So how should we study a constitution? And I want to propose, this is it's a panel on methodology. So I want to think a little bit about the methodologies that we use, that the Constitution is a field of ideas that sometimes is made tangible, which is to say, if you think about it, it's kind of an audacious thing to imagine that words on paper can come to have some reality in the world, right? And so I'm interested in that transition, right? How the words go from being on paper to being something that people take for granted in the world. And so successful constitutional systems, that is where there's some correspondence between a thing that could be called a constitution and then the forms of life it gives rise to, where that happens, people take for granted that the institutions constituted by the Constitution are real, and they have some sense about branches of government or separation of powers or whatever. The point is that a constitution creates a kind of framework for daily life that allows a lot of things to be taken for granted. So then it pushes back to this question of how does the taken for granted work? So I think of a constitution as a kind of mental map, right? Everybody operates with mental maps, and there can be legal mental maps. So what does that mean? It's a sort of idea field. It's a set of ideas that you take to be that get reinforced in your daily interaction because you encounter other people who share the same thing. So I always think when I teach sociology of law, I always say, think of the whole idea of money, right? Like, why, if you give somebody a piece of paper, should they think that's anything, right? And the idea is because there's a whole legal structure that holds it up. And everybody assumes that thing is there. And all you have to do is be in a country with a failing currency to know exactly, that these things can fall apart, right? So a lot of the institutions that we live with in daily life have a kind of legal basis to them. And that's the thing that, that holds them up, essentially. So intersubjectivity, which means that we share these ideas with others, and it's precisely the fact that we share these ideas with others that holds them up, is, I think, the ground on which law operates. So the Constitution is a specialized kind of legal map, right? So as legal doctrine, it's a detailed mental map among lawyers, right? So that lawyers and legally trained people will have debates over what this clause or that clause means, or over what a particular decision interpreting the Constitution means. But for ordinary people, it creates institutions that are real, that just seem real, right? That don't seem like they went from paper to reality. So the question is, and a lot of things, I love this cartoon because, it's like, wow, I'm so glad I was born in this pot and not that pot, right? Which is kind of the origins of citizenship. There's a lot of what are really sort of contingent social practices that become much more rigid and real because of their instantiation in law. Okay, so this is sort of what I want to think of as the background for thinking about constitutions, right? So how do they work? Constitutions constitute, but a lot of what they're doing is operating in this space of the taken for granted, right? You don't every morning wake up and say, gee, is the legislature real? You know, like it's just one of those things that kind of goes without saying after a while. So what happens in societies, and we're seeing this happening in a lot of different places, where there's a kind of polarization, a political polarization, a religious polarization, a kind of set of social groups that no longer talk to each other. And that's the kind of space in which counter-constitutions, which is to say, another way of taking for granted a set of political practices, grows up in one community that doesn't match what's happening in another community, right? And so I think one of the urgent questions of our times is to think about these counter constitutions. Jack Balkin calls them shadow constitutions, but sort of alternatives to the official constitution on offer, right? So you get these when social groups, or when you sometimes have a kind of coup plotting elite, but you get some other group that has a kind of alternative, different mental map, different idea map. And sometimes those alternative groups push into attention the taken for granted and make it unsettled. I speak from, I'm in the United States at the moment. The United States thought of itself as having this reasonably stable constitution until our last president came along and just went through all these norms that people took for granted. And suddenly you realized none of them were legally enforceable. And then you realize that half the country thought the norms that Trump was advocating were his, right? And then you sort of wake up in this system in which everything is disoriented, right? So the taken for granted becomes unsettled and the norms disappear and all you're left with is arguing over sort of positive law. Now, I want to say that a counter constitution, when that moment happens and it really unsettles the constitutional order, it's quite different from what we might think of as a normal challenge. A normal challenge is where, subjects over which reasonable lawyers can disagree, of which there will always be many. And most of us who teach constitutional law teach mostly those things, right? Where's the edge of a legal rule? Where are the places where people are fighting over the meaning of something? But normal challenges leave the core of the constitutional order intact. And you're arguing over boundaries and edges, not over cores. And when a counter-constitution arises, a lot of what you're arguing about is the core. Do we need checks and balances? Would it be better if the president just ran everything? Questions of that kind, which go to the core of the constitutional order and which often are not even taught in constitutional law courses in law schools because they're so taken for granted, right? But if you get a social movement that starts to attack that stuff, then you're really in a kind of different world. What I found now, because I've been studying democratic backsliding and trying to figure out how this happens, how do constitutions that look reasonably solid come unstuck? What you often find is that the counter constitution starts as what I call a professional project. It's something that lawyers do. I've been studying, Poland and Hungary and Russia. One of the things all three of those countries share is that they're run by lawyers, like the people who are literally the presidents, the prime ministers are all lawyers, and they have, their whole team around them are all lawyers. And these are folks who, while they were out of government, particularly in Poland and Hungary, while they were out of government, started creating a kind of alternative legal order, right? An alternative sort of constitutional space. So it starts often as a professional project and then gets disseminated to a larger group. Sometimes social movements or political parties are formed around these counter-constitutional ideas, but they often start from the top. These are American pictures. This is a picture when some of you know that the US was sort of gripped by this originalism movement starting in sort of the 1980s. And by 10 years ago, it had fragmented into a number of different parts, one of which was the so-called Tea Party, which was the kind of pre-Trump group. So a lot of these things have long run-ups. They don't just kind of occur overnight because what you have to change is people's mental maps, right? So how do they develop? I've been just trying to give you a kind of picture. You get these kind of schisms in a society. They often appear in very polarized societies when you have people who develop these different kind of meaning maps. And they're getting them reinforced by others because they only talk to other people who share their own view of the world. These counter constitutions, sort of emerge out of this polarization. And yet people, they come to have a reality if they're reinforced in this social this social interaction. And then it sort of underwrites motivated action. It also may underwrite versions of history. It may underwrite different aspects of culture. And the point is, it doesn't just happen when you amend a constitution, right? This is much broader and more cultural when it's dangerous. And so how to study this kind of stuff, and I'm going to close just on some methodological notes. You can't study this by just reading law books, right? This requires getting outside of what a lot of us do in law schools and think about, participant observation, interviews, archives, the kind of, I like getting myself on mailing lists of groups with which I disagree so I can read all the stuff they're telling their members about, what's real and what's true and what they're supposed to do. All of that means that you have to kind of, you become a student. You have to kind of enter the field of knowledge you want to understand. You have to figure out how these groups are thinking about things, because what looks absolutely crazy from the outside, if you have the more conventional view of things, becomes absolutely normalized when you walk inside these groups. So you have to kind of walk in and you ask people to teach you how it works. Make mistakes so you can be corrected. Try to explain to others, say, well, do I understand this is what you think, and have them correct you? So in other words, one of the ways to do this is to become a law student sort of all over again, and to walk into these groups and have them help teach you sort of how it is that they understand things. So in some sense, you use yourself as a focal point, right, to test whether you understand what others understand. It requires a fair amount of strength to do this, but it's really, I think, a very good thing. I've been doing this both in the US now and also in Hungary, where I've been onto this sort of group of what I call Holy Crown defenders. The Holy Crown of St. Stephen was the sort of tangible object going back to the year 1000, if you believe the Holy Crown defenders, but certainly going back to the interwar period of the last century. This object became a kind of carrier of Hungarian culture, and a whole series of kind of cultural rituals formed themselves around this crown. And one of the ways that Viktor Orban came in and came to power was to adopt this Holy Crown. This is the Holy Crown of St. That's the original. And in this new constitution that Viktor Orban passed in 2011, sort of beginning the end of Hungarian democracy, it opens with this reference to the crown. This is actually the literal language. That's not Monty Python in the picture. That's actually the new Crown Guard with the new uniforms that Orban has just given them, direct copies of the uniforms from the 1930s. And this is now the preamble to the Constitution, which cites the Holy Crown and the historic Constitution of Hungary, and claims that Hungary is now going back to this history that it used to have. All I'll say is that I saw this coming for 20 years before it happened. If you walked into all these sort of right-wing groups, hang out at right-wing bookstores, they were talking constitutional language and really meaning it. And so when Viktor Orban came to power and surprised the world, he didn't much surprise the rest of us. I won't go through this slide. This is what I've been doing to counter his narratives. And we also have this problem with Trump. But I just want to stop there by saying that one of the things that happens if you really start to take this methodology seriously is that you see the attacks on constitutionalism that may be in a functioning democracy long before it comes up and upends it. And so that makes me think that one of the things that scholars need to do is to track all this before it happens, and to be, in some sense, the early warning signal, because oftentimes if you're living in a constitutional world in which everything is taken for granted and everything has become normalized, you really don't see it coming. And one of the things scholars can do is to help everyone see what's on their doorstep. So thanks.
Thank you so much, Kim. I now would like to invite Cheryl Saunders. Just before I do, could I let the participants know that we hope that we will have a little bit of time at the end for some questions and answers, and that you are very welcome to put your questions and answers there's a Q&A button at the bottom of your screen, which you can use to raise questions. Thank you very much, Cheryl Saunders.
Thanks, Adrienne. And let me begin by saying how pleased I am to be involved in this forum. I have a great affection for the International Association of Constitutional Law, and it's always wonderful to be involved in one of its events and to see so many old friends, even if on this occasion only on screen. And I agree with Raul that the Young Scholars Forum is a great initiative, and I congratulate the IACL on undertaking it. Now, I had intended to use my time this morning to talk about two sets of issues with which I'm presently absorbed. One is constitutions and culture, and the other is the external face of constitutions. But on reflection, I think I probably won't reach the latter. And I'm very comforted by the fact that Raul, in effect, has covered one very important aspect of the relationship between comparative constitutional and international law. And I look forward to pursuing those issues with him further at some stage. Now, I've been thinking about culture in the context of constitutions for some time, and I'm presently participating in a very interesting project that's requiring me to do more work on that question. Culture is a topic that tends to encounter pushback in the context of constitutions for obvious reasons. Some cultural practices are deeply antithetical to what I'm sure all of us would accept as desirable standards. Female genital mutilation is an obvious example. And claims of culture can be manipulated for self-serving political purposes, undermining the very basics of constitutionalism. The Asian values debate of several decades ago is often cited, but there are more recent examples as well, and indeed Kim has been canvassing those. Partly because of this wariness of the terminology of culture, discussion of culture in a constitutional context often is limited to what generically is referred to as constitutional culture, which is assumed to be both desirable and homogeneous, although, as Kim shows, it can also regress. So in trying to move beyond this wall of assumptions about constitutions and culture, to tackle an issue that in fact is often relevant in comparative constitutional scholarship, I use a broad definition of culture, including that helpful disaggregation by Roger Cotterill, which defines it to include beliefs and values, tradition, including historical experience, aspects of material culture, and emotional attachments and rejections. And drawing on that definition, I assume, to quote Amartya Sen, that culture has a pervasive influence in human life, including constitutional life, and the real issue is how, not whether, culture matters. So the purposes of my current project, I'm trying at the outset to diffuse some of the usual debate about culture by acknowledging its complex properties. We can assume that culture is not homogeneous. Aspects of it may be understood differently within the same community. Claims about culture are often internally contested. Culture changes over time, including through exposure to other cultures. Culture and constitutions may have a reflexive relationship in which each shapes the other. Every community is influenced by culture in various ways. What it involves may be assumed by the community in question and not articulated in ways that are readily accessed to others. And that then attracts some of those points that Kim made a few moments ago about how you find out the cultural assumptions that are affecting constitutional action. In thinking about the implications of culture for comparative constitutional law, it may be helpful to distinguish not only between regions and states, parts of states, but between communities within polities. Such communities may include the society at large or segments of society, the political class, the bureaucracy, the military, lawyers and judges, and others. Such sectoral cultures are, of course, linked in relation to political, bureaucratic, or military culture, for example. It often will be necessary to understand how the people at large react to the power of those actors. And that itself is a cultural question. It may sometimes be necessary to disaggregate constitutional culture as well. Different constitutions need to play out differently in cultural terms. consider the contrast between so-called transformative and equally so-called traditional constitutions, for example, or between federal and unitary constitutions, or between presidential and parliamentary constitutions. Each of those distinctions brings a certain amount of cultural baggage in its wake, and if it doesn't, then you may be in trouble. The implications of these distinctions in practice can be grasped by considering the case of Nepal. Nepal is presently attempting, with real difficulty, to adjust from the cultures that prevailed, as long as it was a centralized Hindu monarchical state, to the present constitution that establishes it as a secular, federal, democratic republic. And each of those transitions carries cultural challenges for all of the sectors, perhaps not the military so much, that I identified a moment ago. Culture may be relevant in different ways in different comparative constitutional projects. Sometimes, as Kim just suggested, you just need to keep an eye on it. But it will often be necessary simply to understand how culture works. Consider, for example, a search for insights for good practice from the varying legal frameworks for managing the pandemic that have been used in states throughout the world. Sure, there have been very interesting dimensions of the legal framework for the pandemic in many states, and very often the experience of those states suggests that the frameworks have been quite effective, or perhaps not so effective. But in order to understand whether those frameworks are translatable to your own circumstances, you need to understand other aspects of the culture in which those frameworks have been operating. Is the community more or less likely to be responsive to authority, for example? And those sorts of things are critical in drawing insights from the constitutional experience with the pandemic. A second example of how culture might be relevant. When a project involves constitutional change, whether through some form of transplants or not, it may be useful to adopt an approach that maximizes the opportunities that existing cultures offer, so as to make the transition less dramatic, while at the same time minimizing the unwanted impacts of culture. And neither of those two challenges is easy. Consider an ethnically divided society, for example. To what extent should new constitutional arrangements take advantage of the traditional sense of community that those societies offer, at the risk of entrenching deep divisions or entrenching misogynistic power structures? And that's a question that's being grappled with in constitutional arrangements throughout the world without any clear solution as matters stand. Thirdly, whatever the assessment of current cultural settings, any major constitutional change will also require cultural change. Australia may confront this reality soon, if and when the Constitution is changed to establish an Indigenous representative body as a voice to the Australian Parliament. Once that happens, there will need to be major change in the culture of Parliament, the bureaucracy, the government, perhaps Indigenous communities, to maximise the effectiveness of that change. Otherwise, it will be an interesting symbol, but it will make no difference in practice. And my final example concerns language. Language is another lens to working through questions of culture, or accordingly, another hurdle. As Martje de Visser pointed out in a fascinating paper she presented a couple of weeks ago, language and constitutional concept formation may be deeply intertwined that make it hard to compare or even understand phenomena that are routinely translated into English using a term that does not adequately reflect how the phenomenon is locally understood. The rule of law may be a case in point, and Raul, in a sense, was canvassing some of those issues in his remarks a moment ago. And then finally, I raise a question about what, if anything, constitutions might say about culture. The developing focus on constitutions in the global south has made this an increasingly significant issue, not because these communities are the only ones with culture, but because compatibility between constitutions and culture in the global north historically has simply been assumed. To the extent that a constitution codifies, it freezes it, depriving it of a property that may have an ongoing value. But the status of a constitution as fundamental law gives it the potential to override aspects of culture that as community may seek to retain. Codification is one answer, with the consequences that follow from it. Constitutional instructions to bodies, including courts, to have regard to culture is another. And both of those techniques are often used and I think repay further study. But how well such devices work in an age of globalization is another matter, which I hope to follow up in due course. So thanks very much, Adrienne.
Thank you so much, Cheryl, for those terrific remarks that are already provoking a lot of response in the Q&A, on which I'm keeping an eye. We'll just go to Kevin Tan for your remarks, and then I hope we'll have a little bit of time for question and answer. Thank you, Kevin.
Thank you. Thanks very much, Adrienne, and thanks to Jaclyn for including me in this really exciting series of workshops for junior scholars. Like Raul, I think we all appreciate the fact that had we had these kinds of opportunities, maybe our own career trajectories in terms of research might have fanned out in rather different directions. But in any case, I tried to take very seriously the topic that was offered to us in the keynote on looking at sort of methodological challenges and trends in comparative constitutional law. So what I hope to do is to share with you some thoughts on what we do and what the methodological problems might be. So with that, let me share my screen and talk through just two very brief slides that I am offering. This is the first slide where I asked the question, right? In order for us to look at methodology, we need to ask ourselves, what do actually, comparative constitutional law scholars do, or what do comparativists do before we look at what we are doing? And as in life, very often we do things without necessarily always thinking through, methodological hurdles and things like that. All right. I mean, we don't think of things in terms of categories. We just try and look for a research question, something which intrigues us, and then we investigate it. And then figure out, well, did I quite do it correctly, and so on. So, just looking at some major works that have attempted to talk about what comparativists do. You can see, for example, Vicky Jackson in her chapter in the Oxford Handbook on Comparative Constitutional Law suggests that comparativists do a number of things. In the old-fashioned way, you look at sort of classification of legal families, common law versus civil law. Comparativists also look at history in terms of change and continuity in development of legal ideas, legal concepts, even the migration of constitutional ideas. Some search for universal principles, just or good principles. So, good government, what an ideal independent judiciary might look like. And then she talks about a method in which we do it, right, through functionalism. And this functionalism is something that I will come back to in a little while. It is both what we do as well as a method, right? So we may look at the functions of various institutions, for example. How do anti-corruption agencies work in different jurisdictions, or how do parliaments or legislatures work in different jurisdictions? Well, that's sort of in a way a functional approach as well. And then finally, you look at context as a means of expression and self-reflection. Gunther Frankenberg sort of deals with it rather more tightly, he says, well, we compare constitutional archetypes. We may compare constitutional architecture, looking at structures again, institutions, very similar, and compare constitutional transfer. I mean, obviously, the sharing of ideas and influences, internal and as well as external. Rand Herschel, in his Constitutional Matters, lists, I think, a rather more comprehensive list of what we do, right? Which may count as comparative constitutional legal studies. So freestanding single country studies are sufficient. He would consider that as being useful as a comparative tool. Deep studies of single countries. Secondly, genealogies and taxonomic labeling of constitutional systems and orders, which is similar to Vicky Jackson's classification. Surveys of foreign law in order to find the best or the most suitable rule across cultures. References to laws and judicial decisions in other countries, again, for self-reflection through analogy and contrast. Again, so this is like, we do it this way, somebody else does it another way. Is that a better way of doing things, right? Concept formation through multiple descriptions of the same constitutional phenomena across countries. Normative or philosophical contemplation of abstract concepts, something like constitutional identity. What does that mean across the board? And then, of course, the more empirical work, right? Careful small n studies illustrating causal arguments, or big N studies that analyze and correlate multiple elements. Now, this is an entire smorgasbord of what people who work in the field, what comparativists purport to do. My purpose is not to go into any one of them to sort of critique them, but to simply say, well, people who work in this field do any number of one of these things. We may do one type at one point, doing a sort of freestanding single country study, or at another point in time, we may look at things in a functional fashion. So based on all this, what are the sort of challenges we are likely to face? Cheryl has mentioned culture and the importance of language therein, and I'm looking at it from a slightly more practical perspective. If one wants to look at comparisons across jurisdictions, language is very often a barrier. Now, there may be things that are available in translation, but there are things which are inherently untranslatable. So this is one of the major methodological challenges. It's very difficult to do this in a very serious way if you want to look at many jurisdictions, unless you have a great talent for languages, and then you again are limited to the number of languages you are likely to have at your command. So this is one of the issues. Of course, these are not insurmountable, right? The second major problem, which has been discussed by many scholars, is whether or not you can actually have proper units of comparison. Are things really comparable, right? And what is it that we are comparing? Do we compare jurisdictions, country A versus country B? Are we comparing traditions, civil law, common law, Islamic law? Are we looking at comparisons between types of institutions, courts, judges, legislatures, right? Or are we looking at thematic questions or problems, right? Such as, say, management of religious diversity, freedom, free speech, and hate speech. Maybe you're looking at that kind of a discrete thematic problem, right? Now, in doing all of this, the most common and dominant method, which many of us adopt, is a sort of a functionalist method. And the main critique about the functionalist method is that while it kind of works very well, right? You look at the problem, and then you say, well, how do people treat these problems? Is the fact that sometimes the various institutions that we are comparing are not really comparable in that way, right? They don't do exactly the same thing. So a court in country A might actually work very differently from a court in country B, serve a totally different perspective. So if you just look at the court, then you're going to have problems because, you know, this comparison is not going to yield something that is very illuminating, right? So where does this leave us? These are challenges, but that doesn't mean we should stop doing comparative constitutional law because you know, you don't speak more than 2 languages or something like that. I think it is still possible for us to investigate this, and this calls, I think, for a number of things. The first one is an approach, and here I would like to propose a variation of the sort of functionalist approach that we have taken over the years. And this is to take what I call a problem-centered approach, right? So it should be centered rather than center. A problem-centered approach where you look at a constitutional problem that needs to be solved. And of course, it has to do with the Constitution. It's not any old problem. It is a problem which typically a state might look at as something that would involve the Constitution. Now, if you have a constitutional problem that needs to be solved, right? How do we control hate speech? Well, that's maybe a constitutional problem. Then, based on that problem, we then look to comparing how maybe, and here it is, you know, it could be carved up in any number of ways. You could be carved up in the sense of a geographical location. We could say, well, we're going to look at how it works in ASEAN, right? Or we could say, well, no, I'm not going to look at it how it works in ASEAN. I'm going to look at how it works in common law jurisdictions within Asia. Well, that's another way of carving it out. So how and what we compare, I suppose, depends very much on what we are looking for. There is no one way of doing it. I think the method that we adopt is contingent on what we are trying to establish or what we are trying to find out in these instances. So I think methodology is important. We should think carefully about what we are doing, but we should never be shackled by the sort of methodological approaches that we take. And here, I perhaps I should end with a very nice quote from one of the great comparativists, but not in law, but in politics, and that's Benedict Anderson, who in his last years actually, you know, reflected on what he was doing as a comparativist. And he was a great comparativist. I mean, if nothing else, Ben Anderson actually mastered something like 7 different Asian languages to a very high proficiency. So he could do, he didn't really have those linguistic barriers that some of us might encounter. And he said, you know, it's important for us to recognize that comparison is not a method. It's not even an academic technique. Rather, it is a discursive strategy, right? So when we do comparisons, I think we need to take methodology somewhat seriously, because we want to be consistent in what we are trying to do and what at least the reader understands us as trying to accomplish. But at the same time, I think we don't go out there and say, well, no, I'm a hardcore functionalist or I'm a structuralist, and therefore I will investigate a legal problem, a constitutional problem in this particular way. So thank you very much.
Thank you very much, Kevin, and to all our panelists for those really thought-provoking remarks. Now, I've been following the Q&A, and what I propose to do is try to draw out several common lines of thought that are coming through them, rather than to put them one by one, given the amount of time we have. So what seems to me was a common theme through the remarks of all 4 of our keynote panelists was that there is something else besides the law that we need to look at. So we need to look at what I think Cheryl Saunders called culture, and what Keynote and Scheppele, in a rather different framing, referred to as the kind of mental map, which might then give rise to a sort of counter-constitution. This, I think, was reflected also in Raul Pangalangan's idea of comparing law with the other forms of social control that are significant in a society. And of course, Kevin Tan spoke a lot about the deep importance of context. So viewing those as a somewhat similar theme, I'm sure there are differences that you might like to bring out. But here's a set of questions that I think are around this idea. One is, how do we tell what our constitutional culture is? Or how do we tell what counts as a counter constitution? Can we do that in ways that are not hopelessly sort of infected by our own particular stance? And won't we disagree about what they are, and how do we resolve those disagreements? And then lastly, is there a sort of danger to this invocation of a counter constitution, that we might be elevating and normalizing what we actually should rightly regard as, I think what Wojciech Soderski has called in the Q&A, as crazy and dangerous? So that's a set of thoughts, attempt to draw that together. And perhaps I could just ask the panelists one by one if they would like to come in on that. Would anyone particularly like to start? Or perhaps I could ask Kim to come in first then.
Yeah, so these are great questions, and I've been trying to type some answers in the chat or in the Q&A boxes. So the first on what is a constitution? So this is where you're going to see that when I'm not being a law professor, I'm really being a sociologist. And there's a sociologist called Irving Goffman who was famous for trying to teach his students, how do you know what a norm is? And he said, this is a pre-pandemic example, get into an elevator with a bunch of people and face the back of the elevator and see what everybody does, right? And everybody will move away from you. They'll try to readjust. It just isn't the normative thing to do in an elevator. And to some extent, when you're working with not just, sort of written text, but you're working with norms that constitute a culture, part of the way that you know that the norms are there is that violations are responded to by attempting to pull you back into the norm, right? So that's, now you want to, how to put it, you don't want to get people arrested doing this as a kind of methodology for studying constitutions. But that's the kind of thing I mean, that you get this kind of group recognition that a norm has been violated, there's some repair work that's done. And so you can see that happening. Now, when you get a counter constitution, what happens is that the norm violation gets defended by not just one person, but by a whole group. And so what you get are, these splits in a society between one group defending norm A and another group defending norm B. And so it's not just a matter of like an individual norm violation, but it's something that's literally backed up by a crowd. And so, in defense, so what Wojciech was saying is exactly what people said to me when I started studying the Holy Crown of St. Stephen 20 years ago. But I kept saying, but look, there are all of these people, like you go to these meetings of sort of right-wing groups, and they were talking about the Constitution. They thought Hungary had the wrong one. And, as long as they were sort of an isolated group, I think it might have been possible to ignore them. But there was a political party that latched onto that discussion, and that's where Viktor Orban came from. So I think it's always worth paying attention to these things, because you never know when they're going to blow up into something that you really do have to confront. And it's much better to confront it when it's a conversation in the margins than when it's your only option at an election, for example. So that's my defense.
Thank you so much, Kim. Did I see, Raul, that you would like to come in on this? Yes, please do.
Thank you so much, Adrienne. For me, in terms of setting a normative framework, the question that strikes me is, should we do it through a constitution or through a civil code, a Code Napoleon? What is the difference in reshaping in a fundamental restructuring of norms using the instrument of a constitution, or using the instrument of either of a civil code? And for me, doing it through a constitution does it through the public sphere. And perhaps I'm just venturing a thought that doing it through restructuring the norm through a civil code would be recognizing that those norms ought to reside in the private sphere and be more directly felt, not be felt through large public institutions, but rather in the day-to-day relations among people. For me, choosing a constitution for a normative reset, for instance, choosing a constitution as the arena for the shaping of norms is itself a recognition that the shaping of norms is done through an explicitly political communal institution. Let me close at that point, Adrienne. Thank you.
Thank you so much. I can see both Cheryl and Kevin want to come in. So first Cheryl and then Kevin, if I may.
Sure.
You're muted, Cheryl. Yes.
Yeah, I know. Can I come in with that question you opened with, Adrienne? How do you tell what your constitutional culture is, and how do you work out whether it's your own stance or not? And I mean, it depends what aspect of constitutional culture you're talking about, unless you're talking about it in some very generic term. So if we take our own country, for example, there'd be some things that very few people would argue about in the Australian context. There is a sort of a rule of law culture in the sense that we expect that governments, the political class, will comply with a decision of the court, even if it hates it, and it won't even be debated. Now, to go back to Kim's point, you can see that beginning to wobble a bit, but it hasn't wobbled so much that you would say that that particular assumption of culture is unsettled. Whereas if we were to have a debate about whether Australia's federal culture is centralised or decentralised, we might have much more of an argument within our polity. And I may be affected by my own stance because I know where I want to stand on that. And this fits also with one of the questions that was in the Q&A. To what extent can we objectively judge our own constitutional culture? Or to what extent is our judgment always subjective? And I think that's a really interesting question. I think one of the advantages of comparative work is that it helps you to judge your own culture. It makes you conscious that the way in which you think about things is different to the way in which other people think about things. And it makes you ask the question, why? It doesn't necessarily completely overcome the subjectivity point, but it does mean that you can partly go down that track. It also means that even if you're being subjective about it, generally you understand your own system well enough to understand why things are done in a particular way. And this again is another challenge for comparative work. I heard Kim give a very interesting exposition on this a few weeks ago where we were both actually talking about the advantages of really getting inside the skin of another constitutional system as well as your own, so that you can sort of draw these conclusions, and the challenge of getting inside the skin of another constitutional system in which you have not been trained and brought up. And one of the answers to that is by dealing directly with people and asking questions and so on.
Kevin?
Yes, thank you. I'd like to try and answer this question in looking at how we approach a particular subject for investigation, whether we begin with a normative idea about what things should look like. In other words, well, culture should look like this, and therefore these are the phenomena I will look at, or constitution should do X, and therefore I will only look at what it looks like. Now, I think normativity comes in at 2 points, and so it's a kind of a cycle that feeds into a loop, right? And hopefully it's a loop that gets ever more illuminating. So what happens is you go in there and you look at it, there is some normativity that is involved. We have some ideas about what constitution should do. We have some ideas about what phenomena look like. However, once we have some kind of a broad framework as to how we are about to conduct our investigations, then I would say let's go in for the a thick description of what is actually going on. Now, you don't know whether it is an element of culture or it's an element of law or just pure politics, but what is actually going on the ground. And here I'm totally with all of you on empirical research. I feel that, you know, for those of us who do comparisons, at the very least, we need to be, you know, we need to immerse ourselves, even for intensive periods, in those jurisdictions and those spaces that we are trying to study. That's what. So we look at it in sort of a thick description way, and having accumulated all that data, we analyze it, and then we interpret it, and then we go back to the normative and say, well, based on what I've investigated and what I've found, this is what is really going on, and then that normativity kicks in. Is it a good thing? Is it a bad thing? Is it something that would be useful for further understanding this particular phenomenon? And hopefully it goes into the next loop again for further investigation.
Well, this has been such an interesting discussion that I've been given permission from the powers that be to go just a few minutes over and ask another question, which I think sums up a few of the bigger themes that are emerging in the Q&A. And I'd like to put it this way. All of you has emphasised the importance of going beyond the law to really understand what's true, as Kevin just said, what's truly going on. And one of the exciting things about our field, I think, is how interdisciplinary it is, right? So that we draw on other disciplines, and someone like Kim will say when she's not being a comparative constitutional lawyer, she's being a sociologist. But my question is this: for those of us who trained in and work in law school and see our principal intellectual orientation towards the law, what is it that what, if anything, is it that we as scholars distinctively bring to the study of constitutions that is not brought by other disciplines? And perhaps, could I perhaps go in reverse order? Kevin, would you like to address that first, or would you like someone else to take the theme up first?
No, that's fine. What do we as, your question is, what do we as legal scholars, in other words, those trained in the law, bring particularly to the table? I think what we bring to the table are a certain set of skills and a certain understanding of what law looks like, right? So we understand rules, we understand the intricacies of how rules are actually being made, and we have a certain historical consciousness built into us, because many of us worry about how precedents occurred, how rules began. So with those particular skills, I think we find it much easier to deal with the normative questions about law and understanding where law is at the moment before we do that sort of cross-disciplinary investigation.
Cheryl?
Yeah, well, you know, we comparative constitutional lawyers are not a homogenous bunch either. So I think we bring different things. I mean, some of us are more theoretical and very good at conceptual framing. Others are much more focused on what actually works in context. And you know, we all teach in law school that it's not just about rules, it's about how rules work. I agree with Kevin, though, that one thing that lawyers do bring is that they can also understand the rules. You know, other disciplines may be very valuable in understanding political interaction, for example. But if you can't actually engage with the law, you will be missing a dimension very often in the problem that's in front of you. And funnily enough, I had a discussion with someone yesterday about where the Myanmar constitution might go. And they were saying, oh, you know, we need political scientists and we need this and we need that, not just constitutional lawyers. And I said, yes, but you also need constitutional lawyers because they can unravel some of these constitutional complexities. And can I just add one further point? It also depends on what the other discipline is. In thinking about this relationship between international and comparative constitutional law, one of the things that strikes me is because of the character of international law and the way in which it necessarily operates, it's much less concerned with how things actually operate on the ground in states. Whereas comparative constitutional lawyers, for the most part, are interested in the way in which things operate on the ground in states. And that is also shows you how those two disciplines really need to work together in some contexts.
Thanks very much, Cheryl. Kim.
Yeah, so I'm sort of famous for pushing all of my social science PhD students to go to law school and pushing all my law students to go into PhD programs in social science. Frankly, I don't know how it's possible to do sociology of law without knowing law. You know, it's just the thing that you study. It's sort of like trying to study a country without knowing its language, right? Which is to say that it is an intellectual sphere that you have to understand from the inside to understand what the practitioners of it think it is. And the only way you can do that is if you could yourself do it, you know, so it is just like learning a language. It's like for the social scientists in the group who may not have law training, it's like trying to do, you know, statistical models without learning math, right? So it is the currency of the thing we're studying. And I just don't see how you can do that without the kind of knowledge that lawyers have. That said, I think the knowledge of lawyers is not enough, right? And so that's why, just as with comparative law, you can't do comparative law in only one country, right? And so you have to understand at least one other legal system reasonably well to be able to do this kind of work. So, you know, for all my students who try to go down this path, I say it's the most wonderful, the most interesting path. You'll meet the most fascinating people, and it's more work than any other field.
Well, for all our emerging junior scholars here today, I hope they are both, they're greatly encouraged, even if somewhat daunted by that description. Raul.
Thank you, Adrienne. I take the law to be the embodiment, the articulation of the official myth. And I think what we as legal scholars bring to the comparative enterprise is that we take that myth a bit more seriously, either as myth, as a cover-up, as a handle by which to deal with the substance of the relations, whether it's a relationship of power, a relationship of dependency. But for us, the articulation of the myth is in itself an important element of the analysis. Thank you.
All right, well, we have run a little bit over time, and I think I better not start another round of questions, or we may just go well past what is acceptable. So it's now my duty to bring this to a close. I do want to say to those of you who are involved in the next session that, as you will know, it occurs at a separate link. That's the first paper workshop. And you will have been sent that link, so you don't stay in this particular Zoom room. Having said that, it remains for me to thank our keynote panelists. I couldn't imagine a better opening that better put us on the footing that I hoped we'd be on as we explore the papers of scholars over the next few days. Please join with me in thanking our wonderful keynote speakers for your time and for your wonderful insights.